So now let's talk about the complaints to magistrate, which is section 223 to 226. So let's start with section 226. So a magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant. So magistrate having jurisdiction, the very first condition is the magistrate should have a jurisdiction while taking cognizance of an offense. So when the magistrate is taking a cognizance of the offense on a complaint. So when the magistrate has taken a cognizance, when the complaint was made, then the magistrate has taken a cognizance and then shall examine upon oath. So 223 is talking about examination of complainant. So a magistrate will examine upon oath the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witness and also by the magistrate. So provided that no cognizance of an offence shall be taken by magistrate without giving the accused an opportunity of being heard. So the accused also is given an opportunity to heard, provided further that when the complaint is made in writing, the magistrate need not examine the complainant and the witness if a public servant acting or purporting to act in the discharge of his official duties or a court has made the complaint. In this case, no need to examine the complainant and the witness. Or if the magistrate makes over the case for inquiry or trial to another magistrate. So whatever we studied in previous section 212, etc. So that's where we talked about in couple of more sections yesterday we talked about. There could be complaints, the cognizance could be taken or not taken, and what happens in case of a public servant or when a magistrate brings in a complaint and who can roll it back, etc., etc. So in that way, when a magistrate makes over a case or inquiry trial, another magistrate under section 212, then in that case also, no need to examine the complainant or the witness. Provided also that if the magistrate makes over the case to another magistrate under section 212, no need to examine. Now, a magistrate shall not take the cognizance on a complaint against a public servant for any offence alleged to have been committed in course of the discharge of his official functions of duties unless such public servant is given an opportunity to make assertions to the situation that led to the incident so alleged and a report containing facts and circumstances of the incident from the officer superior to such public servant is received. So we already understand from the previous sections that between 210 to 214 and 215 to 222, we understood some exceptions and about the public servant related stuff or the something which is against the state in those situations. So magistrate will take a cognizance of an offence and shall examine on oath the complainant and the witness. So they have to be examined on the oath to ensure that what they are making a complaint to the magistrate is a fact, and they confirm that, they verify that. But it is not required in case verification is not required when it is a public servant or a magistrate itself from a different court. And while we talk about these two conditions, the magistrate will also not take the occurrence of a complaint against a public servant until a report is received from the senior person, a senior officer from the same department, and the such public servant given opportunity to make an assertion. So we understand why this is done. We have studied yesterday also about this in detail, that this is why, because we give some kind of protection to the government servants, etc., and people serving on the various armed forces to ensure that they can do their work fearlessly and without any disturbances. And that is where such kind of provisions are in place to ensure that not easily and unnecessarily their work is hurdled. There is no hurdle presented in their work. So what are the key things about this particular section is the examination of the complainant. So very first thing is the examination of the complainant is something which is an important key factor of this section 223, and it gives a clear procedural guideline about how a magistrate must handle complaints when taking cognizance of an offence, and this ensures a due process and is vital for maintaining the integrity of the judicial system. Now, oath of examination. So magistrate is required to examine the complainant and any witness present under oath. ensuring the reliability of the statement. So it has to be on oath. They have to give a verification, or it has to be an affidavit. So it has to be on oath. And the documentation has to be done. So the examination substance must be documented. It cannot be heard and kept verbally. Hmm. So that is something which is very, very important. Then the rights of the accused. Hmm. So opportunity is to be heard. So before taking cognizance of any offense, the magistrate must provide the accused with a chance to present. So when we talk about the uh, uh, opportunity, uh, we also give an opportunity to the accused. So that is something which is very crucial for the principles of natural justice. Aditya, you are very happy with the lecture today. You're smiling. So protection for the accused. So the provisions emphasize that the need for a balanced approach in handling allegation and safeguarding the rights of individual and validating that the person who is making a complaint is definitely making a complaint uh, which is true, and he takes a responsibility if it is not true. So that verification is required. So exception to the examination requirement is subsection. In subsection 1 is if the public servant or a transfer to another magistrate. In both the cases, it is not required to be examined because that is part of the process. Number 4 is specific procedures for the complaint against the public servant. So there is a special procedure for the complaints against the public servant where the public servant must be allowed to present their side, and it is also required to have a superior's report so that it is properly validated, and then the court can take a cognizance of it. So it is giving a fair trial option by avoiding a frivolous complaint. It is also giving a fair chance by giving the person against whom the complaint is made, the accused, also a fair chance to come back and respond. And it also takes care of the special cases where the complaints might be flowing in from a public servant or from a magistrate itself. That is also taken care. And apart from that, it also takes care of the very specific case where again, if a cognizance of a case against a public servant has to be taken, then in that case, how it has to be, uh, the cognizance has to be taken. So it takes the due precautions also in case of, in general, when a complaint is made, then what precautions has to be taken is it has to be taken on oath so that no frivolous complaint is there, because if person lies on oath, it's a contempt. So then the person would not do that. Then second thing is they also ensure the special conditions of the public servants as well. Moving to section number 224, which is a procedure by magistrate not competent to take cognizance of case. So if a complaint is made to a magistrate who is not competent to take cognizance of the offense, he shall, if the complaint is in writing, return it for presentation to the proper court with an endorsement to that effect. Or if the complaint is not in writing, direct the complainant to the proper court. So it's very common sense based. If I am a magistrate who is not competent to take cognizance, it might happen that people who are coming to present me a complaint might not be aware of that. That's quite a possibility that this is not my jurisdiction. In that case, I know that being a magistrate, I have to come back and I have to send it directly to the right court. And for that, in case if it is in writing, which complaint has come to me, of course, I'll put a note on it and I'll pass it on to the right court, inform the parties to go to the other court. If only a verbal submission is being made about some situation, then I will suggest the party to go and present the matter in the right court and then proceed with the procedure. So basically, if we see the detailed understanding, the first one, 223 was talking about when the complaint comes in, when the cognizance has to be taken, and it automatically means it has to be in the court where it has to be. So it's a competent court situation. So when we come to section 224, it gives a second version where it says, okay, 223 talked about it's a competent court and how they proceed. But what if I reach a court which is not competent? So in that court, it's a responsibility of the court to help the parties to move to the correct court so that the justice is not delayed and it's starting the process in the right court. So in the purpose of what are the protocols given? The protocols given is if it's a written complaint, then return the complaint and put an endorsement. Endorsement will record your version also there, that why it was not run in your court, and it's a normal acknowledgement also. Plus, it is something which will also give you a documentation around that. And in case it is verbal, it has not on paper, no need, no possibility of any endorsement because it's a verbal thing. You can make a verbal acknowledgement and you can ask the person to go to the correct court. So directing the complaint to the right court. So it promotes the judicial efficiency. It helps the protection of the right by directing the people to the right place. And it is encouragement about the legal literacy also, where it helps people, especially where in course of judicial work, like for example, an advocate, to help and understand that, okay, this is not the court and the person will automatically going ahead to follow the correct path. Coming to section number 225, which is postponement of issues of process. So if any magistrate on receipt of a complaint of an offense of which he is authorized to take. So this is a condition when a magistrate is on receipt of a complaint of an offense which he is authorized to take cognizance, or which has been made over to him under section 212. So under 212, it has been made over to him either by the CJM or whatever it is, and may, if he thinks fit and shall, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other persons as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding, provided that no such direction for investigation shall be made where it appears to the magistrate that the offence complained of its tribal exclusively by the court of session, or where the complaint has not been made by a court unless the complaint and the witness present, if any, has been examined on oath under section 223, the first one we talked today, and an injury in an inquiry under subsection 1, the magistrate may, if he thinks fit, take evidence of the witness on oath, provided that if it appears to the magistrate that the offence complained of is tribal, exclusively by the court of session, he shall call upon the complainant to produce all his witness and examine them on oath. And if an investigation under subsection 1 is made by a person not being a police officer, or he shall have for that investigation all the powers conferred by this Sanghita on an officer in charge of a police station, except the power to arrest without warrant. So what it talks about, authority to postpone a process, but we're talking about postponing a process. So a magistrate has also power to postpone the issuance of process, the processes to start, which are to stop, like for the processes of issuance of process, like summons, warrants, etc., etc., against an accused upon receiving a complaint of an offence. So the magistrate can stop that also. And this authority is very significant in case where the initial inquiries may be warranted before taking formal action against the accused. So any inquiry which is required to be warranted before taking formal action against the accused. So BNSS does come back and gives a option also the police as well in that sense to do an inquiry before any FIR is registered, which is clarified by Supreme Court recently. Now, condition 1, subsection 1 talked about jurisdictional consideration, where the magistrate may find it appropriate to postpone issuing process if the accused is residing outside the magistrate's jurisdiction area. So, if the magistrate may find it appropriate that they postpone the process if the accused is residing his jurisdiction outside his jurisdiction, his court's jurisdiction. So, in such case, the magistrate can choose to either conduct the inquiry himself or direct an investigation by a police officer or another suitable person to gather more information about the offences. So before making a decision, if the magistrate want to have some more details about the offences, he can either go back and inquire himself if possible, or ask any police officer or ask any third person, which is normally an advocate or a court officer. Then it talks about the grounds of investigation, that the goal of this procedure is to determine if there are sufficient grounds for proceeding with the case. Because the magistrate has to make a decision, there should be sufficient grounds. And what are the investigation exceptions given here in under A and B? Is it appears that the offence is exclusively triable by a court of session, the magistrate shall not direct on an investigation. Now, if by a initial inquiry by the magistrate, he feels that the crime is such which falls in the jurisdiction of the session court, the magistrate will not direct any investigation because it's completely in the jurisdiction of an session court. So this reflects that the serious nature of certain offences which require a higher court has to handle this. So the magistrate will not get into a situation of investigation in that case. And if the complainant did not originate from a court, the magistrate must first examine the complainant and any present witness under oath as in 223 by taking further action before taking any further action. So basically, if it is something which is not originating from a court has not asked a magistrate to do an investigation. We know that courts can also ask another magistrate, to do an investigation. If that is not the case, an individual has made a complaint, then also what he has to take, the judge has to take consideration is to examine the witness under oath to ensure that he is going to stop the process or postpone the process or not. So subsection 2 then talks about evidence collection. So during the inquiry process initiated under subsection 1, where we said he might go ahead and do investigation himself or via police or a third person who he authorizes, which will have a power of a police officer, the magistrate has the discretion to take an evidence from witness under oath. So under witness also, whomsoever is taking a witness under oath, those people can also be inquired upon and evidence can be collected to take a decision if the postponement has to happen or not. And specific requirement for special serious cases is the offence is exclusively triable by the court of session. Then magistrate must ensure that the complaint produce all witness to examination under oath and establish a factual basis for the case. And if it comes out to be a session case, they will stop it then and there and direct it to the right court. So, but powers of the investigating person, if it is not a police officer, we did mention a person could not be doing a investigation under this section, but might not be a police officer. In this case, the person is granted all the powers akin to a that of a same that of a officer in charge of a police station, but only that the person cannot arrest without warrant. So this ensures a fairness, streamlined legal process, and it encourages judicial discretion, which is very, very important. Judicial discretions are in couple of areas. We have judicial discretions. In those areas, this is a very, very important freedom given to the judiciary, where depending upon the situation, case by case, judiciary has been empowered to take discretions, and those discretions are not a right of any of the party. So nobody can claim that. So any judicial discretion is not a claim, cannot be claimed by any party. It's a decision by the court if they want to have their discretion in this subject or not. So judicial discretion cannot be something which can be enforced. For example, if a judge, if you have to publish certain documents in front of the court, or you have to submit certain documents, and if certain procedure doesn't allows you to submit it more than one time without the leave of the court, in that case it's a judicial discretion because the judge will apply the basics and applications of the law, and the judge will use his discretion to allow or not, because there is also a saying which is considered by the Supreme Court that uh, laws and the framework are there to make things, to enable things, not to become a problem. So in that case, although there might be some procedural limitations, but there is always a judicial discretion given as a ticket which a judge can use depending upon the situation by applying their mind and the right judicial practices to give that person a second breath of life, a second option as well. So judicial discretion is very, very important, which is also applicable in this section. Section 226, dismissal of complaint. So which is now in the previous one we talked about the complaint, the process might be postponed. That's what we said. But then we are talking about a point where a dismissal of a complaint can also happen, which is covered under section 226. So if after considering the statements on oath of the complainant and the witness and the result of the inquiry or investigation under section 225. So in 225, we have postponed everything, we stopped everything, and we have done the investigation depending upon considering the statement on the oath, if any, which is available. So any affidavits are filed, any complaints are filed with the verification, any statement is filed with the verification, and of the witness also as a result of the inquiry by the court or investigation by any police personnel or anybody who is authorized by the court, the magistrate is of opinion that there is no sufficient ground for proceeding. He shall dismiss the complaint, and in every such case, he shall briefly record his reason for so doing. So the magistrate can then dismiss the complaint as well. So it talks about authority to dismiss the complaint. Now, the magistrate, when we just have a give a cursory look from 227 onwards, what the magistrate is doing is the magistrate from, let's go to 223. So, examination of a complaint. So, the magistrate once received, he examines it. 224 gives a power to the magistrate to not competent. So, if I can take, I can take. If not, I'll pass it on to the right court. Then 225 is somewhere where I have if I have some kind of doubt, I can go back and postpone the process and I can do due diligence. And then if I am satisfied that this is something which is not worth to be part of the proceeding any sufficient ground for proceeding, then I can also dismiss as a magistrate. So it is finally an authority of dismiss. So I can, if I would have everything would have been fine before during the before the section application of 225 postponement, then I would have proceeded directly. If it is my court, I'm happy with the statements made. I see the complaint looks genuine and valid, and then I go ahead and it's not looking frivolous. I can go ahead and work. If going ahead, if it doesn't look in my court, I send it to other court applies the same mind. They like, they feel it correct. They apply the knowledge and they proceed with it. If they are not, they want to postpone and want to investigate, they do that. And if everything is fine, okay. Otherwise, they have power to dismiss the complaint. So this authority to dismiss his complaint is section 226, which talks about the statements and the evidences which are taken in 225, and those assessments which are done in 225 becomes a ground for dismissal in the section 226, and the reason has to be quoted. The judge, the magistrate just cannot go back and uh, say it is dismissed. There has to be a legal reason provided there, which uh, which also is kind of accountability to the judiciary also, where just a dismissal cannot happen, because a single dismissal might completely mean a denial of justice to somebody or some parties. So that is why this transparency and accountability is imbibed through section 226, where a magistrate, even if it dismissing, so what the magistrate will do is under 225, the magistrate will do a proper due diligence. So 226 has an effect on 225's actions also. So 225, if it has not done well, 226 magistrate will have no ground to dismissal. So the dismissal grounds also have to be clearly mentioned in 200 as per section 226. Now move to chapter 5, which is inquiry proceedings before magistrates. Now we talk about the inquiry proceedings. So we had postponed the process in the previous chapter. Now everything is fine, and then we start with the inquiry, where we start with the first step is inquiry of the issue of the process. So if the opinion of a magistrate taking cognizance, the magistrate is taking cognizance now in 223. If the opinion of the magistrate taking cognizance of an offense, there is sufficient ground for proceeding. So the statements, the complaints made on oath, etc., is all fine. The case appears to be a summon case. He shall issue summons to the accused for his attendance, or if a warrant case, he may issue a warrant, or if he thinks fit, a summon for causing the accused to be brought or to appear at a certain time before such magistrate, if he has no jurisdiction himself, some other magistrate having jurisdiction, provided that summons or warrants may also be issued through electronic means. So basically, what we are saying is, if the magistrate is able to take a cognizance with all the previous sections under 223 to 226 considered, if he is able to take the cognizance, he decides if summon case, he will issue a summon for the person to come so that a trial can happen in that way. For his attendance, it's a warrant case. Either it way, he may decide to issue a warrant for the person to be brought, or a summon for the person to come and make himself present in the court. But if in case the section 227 1B says, or to appears at a certain time before such magistrate. So this can also be happening with a magistrate who has a administrative role also, and who can also assign it to a magistrate subordinate to them also. So this condition may be applicable to in that situation also. Part 2 of the section 227 says, no summons on warrant shall be issued against the accused under subsection 1 until a list of prosecution witness has been filed. So a list of prosecution witnesses has to be filed, and only then the summon or warrant can be issued. In a proceeding instituted upon a complaint made in writing, every summon or warrant issued under subsection 1 shall be accompanied by a copy of such complaint, because this is a fair way of running the judiciary and the justice system, where the other person has all right to know why the person has received a warrant or a summon to appear in front of the court, so that the person can come prepared with the legal help what is required for him to defend himself or herself. So when by any law for the time being in force, any process, fee or other fee are payable, no process shall be issued until the fees are paid. So if there is a fee required to be paid, a fee has to be first paid before the court will initiate to start serving the issue of the process. And if such fees are not paid within a reasonable time, the magistrate may dismiss the complaint, because then you are not serious about the complaint, you are not complying yourself, and a party who is not complying themselves cannot be given a justice, because justice can only be given to prudent people who are cognizant about uh, their rights. They come on time for that. This was worded in couple of Supreme Court judgments also. Section 227 subsection 5 says, nothing in this section shall be deemed to affect the provisions of section 90. So we'll come back. So section 227, what it exactly says is, this is a condition for issuing process. When we start talking about the issue of the process, what we need to know also is what is the process of the issuance of the uh, process, because the process has to be tested against various options which are which could come. I can just not just go ahead and issue a process without applying any mind or considering any situations. So if it is a summon case or a warrant case, depending upon, I issue a summon as a magistrate or a warrant or a summon. I can also use electronic media nowadays. So BNSS is completely empowered and power packed with a lot of options to uh, use the electronic media. So electronic media can also be used for issuing such summons or warrants. Then there are requirement for witnesses, which is subsection 2. So key stipulation in this particular section is that no summon warrant shall be issued unless a list of prosecution witness has been filed. So that is also something which is very, very important. Okay. So that also has to be taken care. And this is very critical. In technically, if we see, this is very critical, because this ensures that the accused is fully informed that a copy is also given to the person. When the summon or a warrant is issued against the person should get right preparation time by knowing what exactly is the complaint against that person. Then subsection 4 is talking about the fees. So the fees is also one of the compliance which has to be completed, and the magistrate has an authority if the such fee is not paid. Of course, there is one thing which is not mentioned here is, in case for some reason the party is not able to deposit such fee, and the reasons are very genuine and transparent, an application can be made to the court with the right intent and request for waiver of the fee also. But for that very reason, if you see, most of the criminal cases does not have a fee until the Supreme Court. So there is no mostly court fee in most of the cases. If the court fee is already waived off for many of the crimes which is uh, tried under the criminal laws, because it is something which is a crime against the state which is considered. Relationship to the other provision is also given in section 90, is something which is uh, about section 90. What it says is, nothing in this section shall be deemed to be affect the provisions of the section 90. So let's read section 90. It is about issue of warrant in lieu or in addition to summon. So if warrant has to be issued in lieu of or in addition to a summon, those processes just cannot be touch. It has no impact on that. So that is section 90. And let's move on to the next section, which is section 228. So 228 is now talking about magistrate may dispense with personal attendance of accused. So whenever a magistrate issues a summon, he may, if he sees reasons or do so, dispense with the personal attendance of the accused and permit him to appear by his advocate. So he is allowed to appear through his advocate. But the magistrate inquiring into or trying the case may, in his discretion, again discretion, at any stage of the proceedings, direct the personal attendance of the accused and, if necessary, enforce such attendance in the manner before provided. So it is a judicial discretion given that the magistrate may, who is issuing a summon, etc., might also dispense the person that, okay, you could also appear from on through an advocate, because you will see that exactly written on the summon. When you see the summons and such warrants, it is clearly written there. You have to appear and so date and so court for so and so reasons, and under so and so sections, the complaint against your copy is attached, and you are free to be appear in person or through your advocate. So if that is written, which means the person is dispensed to appear in person or through his or her advocate. But it does not mean that this is going to be applicable throughout. In case if there is an option given where the person is dispensed, given an option to appear through his or her advocate, it is not something which is a constant. It is quite possible that the court might, in spite of that, reinforce and force the presence of that person through whatever way or way it has to be done. And that is something which is allowed. Okay. So that is section 228. So basically, it is an authority given to the magistrate that if they see a reason, if they are happy with the reason, they can allow that. And this is again a judicial discretion we are talking about. And what is the reason for such dispensation is the valid reason, either the party has said or the court themselves understands that it is okay to appear that way. So maybe, for example, a accused lives very far from the court, and there are health issues, or the matter is not very so important, not very dangerous or very highly impactful, or for such a crime where it is okay to be appeared by the magistrate and no further inquiry is required at the moment by the for the that particular person. Discretion to require attendance is given in subsection 2, which says in spite of that approval, attendance can be enforced later point of time. This is very, very important because this gives a robust legal process to ensure that the legal process is clearly understood, that it is only by an exception given on discretion of the court that the person may dispense with personal attendance, but it is something which is uh, not a liberty which could be uh, automatically claimed by the accused. So this is for accused. Section 229, when we move, it says special summons in case of petty offenses. Now we're talking about petty offenses, means small offenses, and which are special summons. Now, it is a matter of a petty offense, please keep in mind. Now, if in the opinion of a magistrate taking cognizance of a petty offence, so a magistrate who is taking cognizance of a petty offence, the case may be summarily disposed of under section 283, 284. So 283, 284, using that, magistrate can summarily dispose the matter. How do we do summarily disposition? We take the matter, we have a very, we don't follow the structured way how we do in the warrant cases and how do we have a session where we file the charges, then we go ahead and we ask them to submit the evidences, the document list, the list of witnesses, etc., etc. Then the examination happen, the argument happen, all those things happen. So, in summary, it is a very quick process. In one or two sessions, this could be completed, and which is very much good for petty offences. So, if they want magistrate, they are allowed to run the matter summarily and dispose it, except where he is for reasons to be recorded in writing of a contrary opinion. Now, if the magistrate believes this is a petty offense, but probably uh, it needs, I have a contrary opinion, and I need to issue summon to the people, to the accused, requiring them to appear in person or by an advocate before them on a specified date, or if he desired to plead guilty to the charge without appearing before the magistrate. So they can also submit their response through affidavit through the advocate and to transmit before the specified date by post, by messenger to the magistrate that the said plea is writing and the amount of the fine specified in the summon of it, or if he desired to appear by an advocate and to plead guilty to the charge through such advocate, to authorize in writing the advocate to plead guilty to the charge on his behalf and to pay the fine through such advocate. So, if the magistrate believes that instead of a summary trial, a disposition through summary trial, uh, they want to issue summon and want to hear the person and understand their opinion if they want to plead guilty or they want to file a response or they want to pay the fine, etc., etc., in person or through their advocates, provided that the amount of the fine specified in such summons shall not exceed 5,000 rupees. So it cannot be for any offense which is beyond 5,000 rupees. And part 2 says, for the purpose of this section, petty offense means, now we have to define petty offense also, offenses punishable only with fine not exceeding 5,000 rupees. So petty offenses are only punishable by fines, but does not include any offense so punishable under the Motor Vehicle Act or under any other law which provides for convicting the accused person in this absence of on a plea of guilty. So this will not include any offense so punishable under the Motor Vehicle Act. So Motor Vehicle Act, why? Because the court is different. It's MACT matters and it goes in a more specific court, motor vehicle court. So this is not part of it. Otherwise, any other law also which provides for convicting the accused person in his absence on a plea of guilty. And point 3 says the state government may by notification empower any magistrate to exercise the power conferred by subsection 1 in relation to any offense which is compoundable under section 59 or any offense punishable with imprisonment to a term not exceeding 3 months or with fine or with both when the magistrate is of opinion that having regard to the facts and circumstances of the case, the imposition of the fine only would meet the end of justice. So it has to be applied according to the discretion of the court and as per the procedure of the law. And this can be empowered by the state government, by the government notification to any magistrate, to any relation to offense which is compoundable. Compoundable offenses are where you can settle the offenses between the parties and it is allowed to make a settlement. While in non-compoundable offenses, you cannot do that. So any offense punishable with imprisonment of a term not exceeding 3 months or with fine or both also could be notified by the state government. So authority of issuing special summon. These are the special summons because in petty offenses, it is not required. It is supposed to be finished by a summary trial, but then you are still putting a summon. So what the summon is about, it's about the personal appearance, pleading guilty or representation by advocate, and it limits on fines. And it could be done via the advocate if the court allows so. And petty offenses are something which is only up to the fine of 5,000 or by special state government empowerment up to the punishment of up to 3 months, fine, either of them or both. And if we say talking about the petty offenses, for your knowledge, this is mostly tried by the JMCs. So second class magistrate. Now moving to section number 230. What does section 230 title says? It says supply to accused of copy of police report and other documents. This is a very good initiation in BNSS, where in any case where the proceeding has been instituted on police report. So this particular proceeding is instituted by a police report. Maybe a FIR definitely has been in that case has been filed. The charge sheet will also come. So the magistrate shall without delay and in no case beyond 14 days from the date of production or appearance of the accused furnish to the accused and the victim, if represented by an advocate, free of cost, a copy of following documents: the police report, which is nothing but the charge sheet; the first information report recorded under section 173, which is the FIR; the statements recorded under subsection 3 of section 180 of all persons whom the prosecution proposed to examine as its witness, excluding the therefrom any part in the regards to which a request for such exclusion has been made by the police officer under subsection 7 of section 193, the confession and statements, if any, recorded under section 183, and any other document or relevant extract thereof forwarded to the magistrate with the police report under subsection 6 of the section 193, and provided that the magistrate may, after pursuing any such part of a statement as it referred to in the clause 3 and considering the reasons given by the police officer for the magistrate think proper, shall be furnished to the accused. So what exactly it summarizes, if we see 1 to 5, everything what we're talking about, everything which is supplied to the court, everything has to be given, which is coming from the police or which is coming from anybody else connected with the matter, has to be supplied to both the parties and within 14 days. If the magistrate thinks proper, shall be furnished to the accused. Provided further that if the magistrate is satisfied that any such document is voluminous, he shall, instead of furnishing the accused and the victim, if represented by an advocate with a copy thereof, may furnish the copies through electronic means. So if it is voluminous, very heavy volume, then they will be, the magistrate can allow sending a PDF file as well, which is the digital version. Provided also that supply of document is electronic form shall be considered as duly furnished. So once it is sent, it is considered duly furnished to the parties. So even if it is transmitted electronically by any mean which is allowed to that particular court and which is being used by the court, the moment it is sent, it is considered furnished. So what is the requirement for the document supply? Basically is this section 230 talks about the supply of the accused, the documents, copy of police report and other documents. Other documents in everything else what the police will submit or the some parties connected to the matter that has been supplying. There is a timeline which is restricted, which is the 14 days. And the types of document is the police report, FIR, witness statement, confession and statement, and any other statements which were made in front of the magistrate on oath. And what is there is a provision for exclusion also, where the discretion to review any request made by the police for part of witness statement to be excluded. So if there is a discretion of the court available to review any request made by police for the parts of witness statements to be excluded. So witness statements might be excluded on request of the police. And if this on their review, if the magistrate also is in the same opinion, that can also prohibit that statement part could be uh, not shared. And then it talks about the voluminous document, big documents. What it says is it could be electronically submitted also, which is also allowed. Moving to section 231, now which talks about supply of copies of statements and documents to accused in other cases triable by court of session. So where in a case instituted otherwise than on a police report, it appears in the magistrate, it appears to the magistrate basically that issuing process under section 227, the very start, the very first section we studied in chapter 5, the offense is triable exclusively by the court of session. The magistrate shall forthwith furnish to the accused free of cost a copy of each of the following. So when they believe that it is a triable by a session court, then the statements recorded under 223 of or section 225 of all persons examined, where the court has reached to a conclusion that it has to go to session. So the reason is also included along with the statements on which the statements were recorded of the witness or the complainant, and the statements and confession, if any, recorded under 180 or section 183, which is a statement disclosed to the magistrate, and any document produced before the magistrate on which the prosecution process proposes to rely. So all those documents has to be also disclosed to the accused, even if this is a case which is not initiated by police, and this is by any person, instituted by any person, and not through police report. So provided that if the magistrate is satisfied that any such document is voluminous, they can also furnish a soft copy, which is a PDF file, to the thereof, and they will also, that he will also be allowed to inspect it either personally, and they can do it through an advocate also. They can also allow to be inspecting the document. So if the magistrate is satisfied that such a document is voluminous, he shall, instead of furnishing the accused with a copy thereof, direct that he will can only allowed to inspect it personally also. So in this section, it is also allowed that the accused is allowed to inspect it personally also, standing in the court through themselves or through the advocate. So this is basically a section which provides a certain documents and statement which how it has to be shared with the accused in case of a case which is not initiated by police, a private complaint which has been made, and the required document and statement, how it has to be done is statement. Subsection 1 talks about the statement recorded, the statement of confession, or any supporting document to be supplied. And consideration for voluminous document is it could be also be allowed to check in person in the court by the accused or by their advocate. And there is an option of electronic submission also, which is also possible. The last section in this regard is commitment of case to court of session when offense is triable exclusively by it. So please understand, we have been talking since last two modules that the matter to the session court, which could come only for in the session court by if it is uh, only a very heinous crime or something, a very big offense, which is by nature of it uh, is marked to be part of session court, which is something which is by default coming to the session court as known that way. Otherwise, the cases come via magistrates. The magistrates will pass on the matter to session. So session receives maximum cases from validation by the magistrate. So when in 232 is the section where this validation is executed for in this regard, where when in a case instituted on a police report or otherwise, so private report also, the accused appears to or is brought before the magistrate, and it appears to the magistrate that the offense is triable exclusively by the court of session, he shall commit, after complying with the provisions of section 230, 31, etc., whatever we have just seen right now, the case to the court of session. So then they will commit it to the court of session, and as per the complying with the provisions of section 230 and 231. So they will also provide the documents, and then they will commit the matter to the court of session, and subject to the provisions of this Sanghita relating to bail, remand the accused to custody until such commitment has been made. So in between the time when the case has been, so complying with this, the case has to be committed to the court of session. But as subject to the provisions of the CRPC, anything related to bail, remand, etc., of the accused to the custody will be handled by the time the commitment has been made. By the time it has gone to the session court, in between that time, this court will manage, the magistrate will manage the bail or remand, etc. Subject to the provision of the Sanhita relating to bail remand, the accused to custody during and until the conclusion of the trial, and send to the court the record of the case and the documents and articles, if any, which are to be produced in evidence. So whatever was submitted there will be forwarded to the sessions court and notify the public prosecutor of the commitment of the case to the court of session. So PP will also has to be notified, provided that the proceeding under this section shall be completed within a period of 90 days from the date of taking cognizance. So within 90 days, they have to move it from this court to another court, which is why, to ensure that there is a speedy course of action which takes place. And such period may be extended by the magistrate for a period not exceeding 180 days. So max 6 months, the magistrate can keep it with them before they move it to the session court. And provided further that the application filed before the magistrate by the accused or the victim or any person authorized by such person in case tried by a court of session shall be forwarded to the court of session with the commitment of the cases. So basically, this is an authority to commit a case, which is a very important authority because that is how the session courts receive the cases mostly. And the conditions of commitment, whatever is given, is the commitment of the cases, remand during the trials, and sending the record, etc., and such activities which needs to be taken care in between when the commitment happens with the other court, and the notification of a public prosecutor also has to happen. And how this happens is through the DGP office, Director General of the Prosecutor Office, which is available in that particular court, otherwise through the Public Prosecutor's Office. Timeline for the proceeding is given 90 days max. Within 180 days, it has to be done. Forwarding application option is given in subsection 3, which talks about the applications are filled by the accused, the victim, any authorized individual, etc. Those applications also be forwarded to the court of sessions. So everything what the court is holding will pass it on to the sessions court. So that is section 232.